It's the client's constitutional right to know and have all the evidence they have against them.
The 17-year-old Montrealer who had allegedly pledged allegiance to the Islamic State and was allegedly ready to carry out at least one attack on behalf of the terrorist group returned to court on Tuesday. The teenager is facing 5 charges in total, 3 of them terrorism-related, that include facilitating a terrorist activity, participating in the activity of a terrorist group, and providing or making available property or services for terrorist purposes. On Tuesday, the federal Crown prosecutor in the case revealed that the Attorney General of Canada informed him that certain evidence could not be shared with the defense at this time until a federal court determines if it must be withheld because it poses a threat to national security, national defense, or international relations.
The Attorney General is claiming privilege under Section 38 of the Canada Evidence Act over certain evidence that is relevant, but is not to be disclosed until the federal court decides whether it should or not be disclosed.
Without this evidence that is not being disclosed, the defense says that it cannot proceed with the trial, so a new court date of December 18th has been set to get an update on whether this evidence can be shared.
It can abort the trial altogether if if this evidence cannot be given to the defense and this individual cannot defend himself. Well, it's an application to a judge to drop the whole case. And sometimes, even if this information is too sensitive and it's the Crown or the Attorney General do not want this information to come out at all, but it's necessary for the individual to defend himself, they might just choose to just not continue to prosecute the case.
The court will balance all those issues and the court will decide. So it's not a question of a mistrial. The court will decide whether or not to disclose. The law provides that if a court is of the opinion that the trial would be unfair, the court could even go as far as to stay the proceedings. But of course, that's very premature. Now we're going to wait for the federal court to do its work and decide what, if anything, could be disclosed.
The youth was arrested on August 20th in Montreal's Côte-des-Neiges NDG borough. In court, the 17-year-old wore a long-sleeve black shirt, he was not handcuffed, and his mother was also present. As
you heard defense counsel, he's taken the position that the case cannot really advance in a meaningful way until he has the answer from the federal court. That's why the case has been postponed to be spoken to and not to proceed on December 18th. Hopefully by then we will know when the federal court hearing will take place.
In Montreal, Gareth Madoc-Jones, City News.